If you hold a green card right now, you might be terrified. You're seeing headlines about deportations in 2026. You're wondering if your permanent residence is actually permanent. You're scrolling through social media and seeing posts claiming everything changed overnight. Stop. Take a breath. I'm about to cut through the noise and give you the actual facts. I'm John from Dream Visa Updates, and I'm going to show you exactly where you stand under U.S. immigration law today. Here's the most important fact. Your green card status has not changed. The legal protections that come with lawful permanent residence are still in place. But I understand why you're anxious. There have been policy announcements, executive actions, and legislative proposals that sound alarming. So let me walk you through what's actually happening, what's being proposed, what's already law, and most importantly, what you need to do right now to protect yourself. Let me be crystal clear. A green card is not easy to lose. When you become a lawful permanent resident, you receive protections under U.S. law that don't disappear based on headlines or executive rhetoric. Those situations where you can lose status are defined by law, not by emotion or politics. Under existing U.S. immigration law, a green card can be taken away in specific circumstances. First, you can lose your status through deportation if you're convicted of certain crimes. The law defines crimes of moral turpitude and aggravated felonies. These are serious criminal convictions, not minor infractions. Crimes of moral turpitude include fraud, theft, and crimes of violence. Aggravated felonies include drug trafficking, crimes of violence, and certain other felonies. If you're convicted of one of these crimes, you become deportable. That's the law. This is not new. Second, a green card holder can face removal for security-related offenses or terrorism support. Again, this is existing law. Third, you can lose status by abandoning it, leaving the United States with the intention not to return or establishing permanent residence in a foreign country. These are situations where you essentially declare you no longer want permanent resident status. Now here's what you need to understand about January 2026. There are policy proposals being discussed. There are enforcement priorities being announced. But none of these change the foundational law about who can be deported and why. If you hold a green card, and you have not been convicted of a crime of moral turpitude or an aggravated felony, and you have not engaged in terrorism, and you have not voluntarily abandoned your status, the law does not authorize your deportation based on your immigration status alone. Let me address something circulating on social media. Some posts claim green card holders are being deported en masse for minor issues, or that new rules allow deportation for traffic violations or minor offenses. This is not accurate. A traffic violation is not grounds for deportation. A minor misdemeanor is not grounds for deportation. The law is clear about what rises to the level of deportability. What has changed is enforcement intensity and enforcement priorities. Immigration and Customs Enforcement receives directives from the executive branch about where to focus resources. In January 2026, enforcement priorities emphasize criminal convictions as a focus, but enforcement priorities do not change the law. If someone is not deportable under the law, they cannot be deported regardless of enforcement priorities. Has anything changed about green card sponsorships, work authorizations, or family-based immigration? There have been policy discussions about making legal immigration more restrictive, but as of today, in January 2026, the core legal pathways for green card sponsorship have not fundamentally changed. Family-based immigration still exists. Employment-based immigration still exists. The visa lottery still exists. Humanitarian pathways still exist. These may be subject to new regulations or new processing priorities, but the pathways themselves have not been eliminated. If legislation is proposed that would change green card law, that bill must pass both the House and Senate and be signed by the President. The process takes time, and here's what's critical. It would not apply retroactively to green cards that were already granted. Immigration law has a principle called prospective application. When rules change, they generally apply going forward, not backward. Now let me talk about what you should actually be doing right now. If you hold a green card and you're concerned about your status, ensure your paperwork is absolutely in order. Make sure you have your green card. Make sure you have filed every required tax return because immigration law requires permanent residents file tax returns on their worldwide income. If you haven't filed, address this with a tax professional and immigration attorney. Second, avoid any action that could be interpreted as abandoning your status. Don't stay out of the United States for extended periods without filing for a re-entry permit. If you need to stay abroad for more than 6 months, talk to an immigration attorney about getting a re-entry permit before you leave. Without it, the government could argue you've abandoned your status simply by your absence. Third, avoid any criminal behavior. Even a conviction that might seem minor could have immigration consequences. A domestic violence conviction, even a misdemeanor, can have serious immigration implications. A drug-related conviction, even for marijuana possession in states where it's legal, can trigger deportation because it's still a federal crime. If you're ever arrested or questioned by police, you have the right to remain silent. Use it. Ask for a lawyer. Don't answer questions without a lawyer present. Fourth, maintain your green card lawfully. Renew it before it expires. Update your address with USCIS if you move. Keep your documentation organized. When your green card is about to expire, file Form I-90 to renew it. Don't wait until the last minute. Fifth, if you are considering becoming a U.S. citizen, this is worth serious thought right now. Citizenship is the strongest immigration status you can have. A U.S. citizen cannot be deported. If you've held a green card for the required time, consider applying for citizenship. But if you have a criminal history that might disqualify you from citizenship, consult with an immigration attorney before doing anything, because applying for citizenship and being denied can trigger removal proceedings. Let me address enforcement intensity. There have been reports of increased enforcement operations targeting people with criminal convictions. But here's something important. ICE cannot enter your home without a warrant signed by a judge. If someone comes to your door claiming to be immigration enforcement, ask to see a judicial warrant. An administrative warrant is not the same as a judicial warrant. If they cannot show you a warrant signed by a judge, you do not have to let them in. You can say, "I do not consent to a search," and refuse to open the door. This is your right. If you are ever taken into immigration custody, you have rights. You have the right to remain silent. You have the right to talk to a lawyer. You have the right to contact your family. You have the right to request an interpreter. You do not have to sign anything without a lawyer reviewing it first. Immigration removal proceedings are court proceedings, and you have the right to legal representation. U.S. immigration law is structured to be applied without discrimination based on country of origin, religion, or political views. The law itself does not authorize immigration enforcement based on these factors. If you believe you are being targeted for removal based on a protected characteristic, that is a basis to challenge removal in immigration court. Let me address public benefits. There is a concept in immigration law called public charge. But if you already have a green card, the public charge rule generally does not apply to you. Public charge primarily applies to people seeking to come to the United States or seeking to adjust their status. If you are already a green card holder, you can generally receive benefits you are eligible for without that affecting your immigration status. The immigration law that protects green card holders is based on statutes written by Congress. It's not based on executive preference, and it doesn't change overnight. Your green card is a significant legal status. It comes with protections, and it also comes with responsibilities. The best way to protect yourself is to stay in compliance with those responsibilities. Keep your paperwork in order, avoid criminal behavior, and have a relationship with an immigration attorney before you need one. The information I've shared is general immigration law information. It is not personal legal advice. Your situation is unique, and only an attorney who reviews your specific facts can give you advice tailored to you. If you are genuinely concerned about your green card status, consult with a qualified immigration attorney. Organizations like the American Immigration Lawyers Association can help you find an attorney. There are also nonprofits that provide free or low-cost immigration legal services. Rely on official sources for information. The official USCIS website has current information about green cards, naturalization, and work authorization. When you see a headline on social media that makes you panic, ask yourself, is this coming from an official government source or someone with an agenda? The answer will tell you whether you need to be concerned. If you're a green card holder watching this, while immigration law is always subject to change through the legislative process, the status you have today is protected by law. You were granted permanent resident status because you met the requirements for it, and the law does not authorize taking that away without cause. Focus on what you can control. Keep your paperwork in order. Stay in compliance with the law. Maintain your connection to the United States. If you are considering citizenship, that is a strong option to explore. And if you are ever uncertain about your status, talk to an immigration attorney. If this video has been helpful, subscribe to Dream Visa Updates. We create content regularly to help you understand immigration law as it actually exists, separate from panic and politics. If you have questions about green card status or immigration law, leave a comment below. Your questions help us decide what to cover in future videos. Share this video with anyone you know who holds a green card. Accurate information is the best antidote to fear-based headlines. Thank you for watching, and thank you for trusting Dream Visa Updates.